Okay, get started. Okay, we started.
Welcome everyone. Our webinar has started. We are just allowing 2 minutes for participants to join. We're going to start 2 minutes. Welcome. Okay. Welcome again, everyone. Thank you for joining us for this webinar. We are going to have a conversation about Amicus Curae, but I want to introduce myself and just explain where we are at, because it's important where this conversation is happening. We are having two big litigation institutes, which is capacity strengthening activities that Islam conducts twice a year. Runs a curriculum with feminist litigators from different African countries. And as part of our Feminist Litigation Institute, a significant part of the work is to strengthen the capacity of feminist litigators who are based in human rights organizations to conduct strategic litigation from a feminist perspective. And this conversation that we are having today has actually come full circle, because it started in another Feminist Litigation Institute in October of last year, where in the context, in the space of having conversations about practices and procedures that can sometimes lead to development of feminist jurisprudence or hinder the development of feminist jurisprudence, the practice of Amicus Curae came up, and we highlighted a lot of challenges that came from the different countries in Africa that are in terms of implementing this practice. so from that conversation, we went into a process of developing a publication to address some of the gaps and inconsistencies that came up in terms of standardizing the need to standardize the practice of amicus curiae as a significant way of developing feminist jurisprudence. Can you hear me? We've seen the comment from the chat that the audio from the room is low. If you can help us to work with that audio so that our participants can hear us. Right, so we have to put the mic really close to the microphone. Thanks for that comment. So, ISLA then went into a process of developing a publication to essentially put together comparative perspectives of amicus curiae practices in 7 different African countries. And today we are launching that publication. So I will speak briefly to introduce my panelists who are joining us today. I'll start here. We have Val Jogu Nyokabi. She's a feminist litigator from Kele, Kenya. And we have Baset Sana, who's joining us from CALS. She's also a feminist litigator within our network. To my right, immediately, I have Sogle Nashe. She's the executive director of ISLA. We have Big Kayaga, who's joining us from Uganda, from the Women's Pro Bono Initiative, also a feminist litigator in the network, and Kubana, to my far right, who's from Malawi, a feminist litigator. The most amazing thing about my panel is that these people have written the publication that we are launching today. And the publication was written in a context where there's very little information sometimes in certain country contexts where there's no literature or a lot of thinking that has gone into the practice of amicus, and it involved a lot of conversation with fellow litigators to gather this information and document the practice in their context. We also have a participant who's joined, a panelist who's joining us online. She's with us in the room, but we wanted to make room for translation and interpretation. So Ariane Agwam is joining us from Burkina Faso, also a feminist litigator in the network. We have 2 discussants who will come up later. They are also authors or chapters in the publication. Dr. Abigail Osiki, who wrote the chapter on Nigeria, and Kago Momotengi, who wrote the chapter on Botswana. So we'll be getting their comments later on in the day. So to start us off for this conversation, I want to start with this story. And I want to ask, we are feminist lawyers. Sometimes we don't even like the law. And here we are, publishing a publication on not just any legal issue, but like a very practice issue, the amicus curiae practice. Why is this important for feminist lawyers?
I think most of the time when we talk about feminist lawyers, people correctly so see us as people who challenge the law because the law does not see women, and so we want to be seen. But the work that we do is about creating an enabling environment for strategic litigation to happen. And also a recognition that procedures like Amicus have really been helpful in making sure that the courts do see women in other groups that it was not designed to see. So when we go to court to do amicus briefs, we understand that what we are asking of the courts is very big. We talk about separation of powers, we talk about the role of the legislature, and when you think about what it takes to develop the law and the work that we are doing, asking the courts to strike that down, we have to place courts in a position where they have the best possible information to arrive at the decision that they need to arrive, at. Just think about the whole law reform engine, which is a law reform commission. And the judges are sitting there with their research clerks, and all of that. And the submissions from the parties who are trying to persuade them to find one way or the other. So it is important when we do constitutional or human rights litigation, because we are really asking them to build something, to say there is a gap here, to say that this thing violates rights, and to make a finding on whether a law should exist or not exist. So we go to court to help surface how gendered the law is, because that still remains a challenge. Most of us who come from common law, jurisdictions, we were taught that the law, is the law. So you should interpret the law as it is, not as it should be, or how you want it to be. And the work that we do sometimes is about asking, why is this law, the law, because we understand how the law has consistently not seen us. So we go there, we want to help them understand the context, how a particular law or practice applies. We want them to have an understanding of how a particular rule or even law has developed. Some of the laws which are often referred to as legacy laws, the colonial, impact of gender discriminatory law, like the refusal to criminalize marital rape, the Married Women's Property Act that we also inherited from the British, or also laws that criminalize consensual same-sex sex. We go to court to do amicus to say that these things have changed, across the world. So what existed in 1852 is not what we are dealing with, right now. So it's a question of what is it still doing in our statute books when even the people who gifted us these terrible legacies no longer see them clean. We also want to say there are people who are developing, laws. So please do have a look at all of these laws and how they have developed, because clearly this cannot be. Or we want to say that our the United Nations, the treaty bodies have developed standards. Our regional human rights mechanism and other comparable have developed all of these standards. So we want you to develop our jurisprudence to be in line with all of these standards. So the number of reasons why amicus are important, but the most important one is to help courts arrive at a decision that really helps us to domesticate international law, or at a regional or international level, to make sure that whatever it is that they are making their decisions based on is consistent with emerging practices and also the standards that have been developed.
Yeah, that's thank you for that, Sophie. And I want to come to you, Kabi, just to talk about the Kenyan context, because what we're hearing from Sophie is important. It's like a tool or a means through which we can help the court see, how to, the way in which men are seen by the law. But what came up in the publication chapter we hear from you is that it's not a practice that always kind of existed in some of our common law jurisdictions. So speaking of Kenya specifically, help us understand the evolution of the practice of amicus curiae in Kenya, and where are we now? Can feminist lawyers go to court and this using amicus?
You're right. The promulgation of the Constitution as sort of midway. So prior to that, when we were doing our research, we found that the scriptures of locus are really what should guide courts in determining who should even participate in proceedings. And really because Amicus couldn't align with one direct interest in the case or to any of the parties. It wasn't really a practice. But in 2010, we then got this new transformative constitution that is actually intended to be an instrument for social change. And the friend of the court is actually anchored within the constitution, within the Bill of Rights, where a duty is placed on courts to ensure that they are interpreting and upholding the rights contained in the constitution. And one of the things that the Chief Justice is duty bound to do is to make rules for the participation of Amicus. And one of the interesting things is that while the question of interpretation of how the Bill of Rights is applied is usually a result of the High Court, with respect to the practice of friend of the court, the Constitution doesn't say that it's only in the High Court. So reading that in a purposive interpretation, what we get from that is that it means that at every level there can be the practice of Amicus. To supplement the Constitution, there are rules. The most popular are what we call colloquially the mutual rules. Now, these rules have been made to facilitate the admission of Amicus. So on paper, they're also very friendly because an application for a party to join Amicus can actually be made already, but during proceedings, and of course, there's the formal call procedure about now making that application. We also have Supreme Court rules that recognize the admission of Amicus, and it says what they need to do. So over the years, in the last 10 years, 10, 12 years now, what we have seen is that courts have developed sort of three-pronged test that they're sort of fairly consistent when determining whether or not a person can actually apply to and be admitted as Amicus. The first is the question of the expertise that this person is bringing on board. And what this has meant for feminist litigation is that in controversial questions that are touching on women's rights, for example, in questions of division of matrimonial property, courts have admitted various parties, various NGOs who have expertise, who have worked on this issue for long periods of time to come on board, to bring in an additional perspective that's not necessarily given by the parties, as long as they're able to demonstrate what kind of work they've done around this. The second test has to do with the impartiality. And this particular is quite controversial because if you've worked on an issue for a long period of time, the question becomes that can you truly be impartial? But courts have still been able to say that yes, as long as the information is being brought that is grounded in law, then you are able to be an impartial party because your interest is not necessarily the outcome between the two disputing parties. It's about what additional information you give it to the court that will help guide it as it makes its decision. And the third one is the public interest. In most of our constitutional human rights litigation, a lot of the issues that are being brought out of public interest. And for us as feminists, we know that the courts are a way that we can achieve social change. So it's in the public interest for us to actually contribute to these cases. That three-pronged test is what is sort of being applied fairly.
Okay. I think our participants would have liked to see you give that we spoke. Thanks for painting a picture for Kenya. I want to come to you, Beatrice, and ask, you've had some of the tests that the courts in Kenya have sort of put in place, this issue of expertise, impartiality, and public interest. What's the story in Uganda? Because we know, that the courts have sort of, they led the way, but we know your chapter documents this 2021 rules of procedure now that are, the rules, the Judiciary Act rules that are going to focus on Amicus. Tell us how we sort of got there.
Thank you so much for that wonderful question. First of all, let our audience to understand that the practice of Amicus in Uganda is relatively a new practice that the courts have decided to take on after a very long period of time, because before the courts have been applying a very conservative approach as to who can approach court as amicus. And this had to be upon invitation by court through an application. And this means that many people were left out, and issues of public interest would not be addressed in one way or the other because of that conservative approach. And to me, every time I read that case of Silver Spring versus Attorney General, which laid down that conservative approach, the question that came to my mind always was what criteria was the court using to select someone to appear as amicus before it? Did they have the expertise? Would they advertise for people with the relevant experience that they needed? So I really wanted to know how that person would have handled that if I told Uganda remained in that very same dilemma. However, in 2016, the civil application that was filed by Professor Olopa Onyango, in this case, the court lays down the principles that are relevant for someone to appear as amicus. And in this case, it is more progressive compared to the first case that is Silver Spring. And in this case, the court was mainly looking at the fact that the person must have expertise, just like in Kenya, and also they must be neutral. The discretion was mainly by courts to admit someone as amicus, but they must have all that criteria, that they were neutral, that they were arguing points of law, that they were not introducing new evidence. And we find that this progressive law, this progressive decision basically came from the fact that the judges recognized the fact that we were in a progressive environment that was around us. They looked at the fact that many jurisdictions, mostly the common law and the civil law, were actually admitting amicus. They also looked into the fact that Uganda is a member of the East African Community, and the ESCG, that is the East African Court of Justice, was admitting amicus. And actually, some of the applications was by the same Ugandans who had made those applications. It also looked at the fact that Kenya and South Africa already had in their constitutions the procedure of admitting amicus in any matter before court, and therefore it was a matter of time for Uganda to also proceed and move in that very same direction. Otherwise, we would not have moved at all. The judges were not aware of the context in which we were operating to admit amicus. But it also made you look at the issue of justice, that the public interest override the other technicalities when it comes to admitting amicus. And so on that note, the court has admitted these parties as amicus the very first time based on an application, but then the criteria for admitting amicus is still the same. It's similar to what Kenya is practicing, that you try arguing the points of law, not introducing new evidence. So basically, there is a similarity, and we, Uganda, has borrowed from Kenya.
Right. Thanks for that. You highlight an issue that came up consistently in the different chapters, but I saw it grapple with the most in Kumbana's chapter. The issue of impartiality, neutrality. Can we, as feminist litigators who are positioned in our human rights approach, how do we reconcile this requirement for neutrality and impartiality that comes up in many jurisdictions? How do you reconcile that for Malawi?
That is very true, and it's something that is still grapple with it.
right now, because most of our laws, including the Amicus, is a legacy that we inherited, and laws and practices, they've gone through transformation. But the tools that we're using now, even in the admission of Amicus, is something that has been there from long time, that we just inherited. We just put it in our laws. But then there's this new era where feminist litigators in organizations, they are in line with what is happening in their country, the state's obligations, the international law, and the need to align state obligations with international law. So most of litigation in Amicus Curae is looking more on human rights and what are the state's obligations of that. So if you find an organization or a feminist litigator, a group of feminist litigators who are applying for Amicus, when they apply for Amicus, they have an agenda, they have interests that are working with, and they're interested in that particular case because they want to give in their expertise, they want to give in their research, they want to put in additional knowledge that has been, that is not before the court. So how is it possible just to be in the middle, that you're not showing your interest, that can you've been working with the theory of change with this. It's you're putting in your additional research or additional comments to a case, and then you say whatever comes out of this case, I don't mind, as long as you know this side and you know this side. So in taking a realist view, it's somehow it kind of makes the Amicus a bit disempower it a bit, rather than it, hearing from your party that the courts in Kenya have allowed that Amicus would have the Pakistan points and they are allowed. But as the tools in Malawi at the moment, you're not allowed to take sides, you're not allowed to have interests, you're not allowed to be partisan. But then that defeats the whole purpose of bringing in new research, additional comments that you want to add meat to the case that is before you. I think in this conversation, there are quite a few things that we kind of get, that we conflate. A person who has an interest in a case can be defined as an interested party because you have an interest in the outcome of the case. And the way in which certain courts have gone on to talk about this interest, or it's to make it look like people who have expertise in a particular area are somehow not eligible to participate as amicus because they are somehow too interested, in the outcome, because they know. But here is the contradiction. Who are these people who have so much expertise on something they are not interested in, right? So the thing that we need to be looking at is, when we find our brief before the court, you don't ask necessarily about what we do or what it is that we want to advance. You look at what it is that we are providing before the court. Because if we are providing and have consistently been able to do this, to say that this is how the law has developed or developing, and we know this because, of course, we are interested because that's where our expertise comes from. But I think we need to push back, against this idea that expertise, the work that we do, that makes us experts in a particular area, somehow disqualifies us.
when we go before the court. So this idea of being too interested by virtue of the work that you do should not be, because almost everywhere, people initially, Amicus was by people who were considered experts. So there will be academics and all of that. But increasingly, when NGOs go to court, they go to court because it is an issue, that they work on. And so Amicus becomes a vehicle for saying, let us help you as a court, let us work with you to actually align our domestic laws or our regional jurisprudence with international human rights standards. So I just thought that's something that we saw in there, that there is a grappling on this, but it is something that we need to consistently push back against, that expertise or interest that an organization has by virtue of its thematic area of focus is not the opposite of neutrality when one goes to court.
Absolutely. And I think the country context that has demonstrated that the most is South Africa, because we've seen how you can be an expert and be an NGO that works towards certain outcomes, but that doesn't disqualify you. And you've seen how, organizations from the socioeconomic rights cases, because a lot of us are learning from how Amicus has developed human rights jurisprudence in South Africa in general, through anchoring expertise, in the work that they do to do this. And if you can tell us a bit, Basi, about how in South Africa this has happened.
Sure, thanks. Thank you so much for hosting this very important conversation. I think that, as you rightly point out, that South Africa does have quite a rich jurisprudence, showing that Amicus participation is something that the courts, specifically the Constitutional Court, has been very, very welcoming on. And we have a many number of, I would say, very positive landmark judgments that echo across, around the world, for example. That echo around the world. And to just maybe point out, one of maybe the most important cases is the Curae case. So this is the South African government versus Curae. And in that particular case, we're concerned a group of people who were being evicted from private land. And the judgment in that particular case then introduced the idea, or rather the rule, that where someone is facing eviction and that eviction would render them homeless, that alternative accommodation is something that is to be, is compulsory, that the city in question provides for those group of people. The question for me with all of these landmark cases is, but then what is the impact on the ground? I think that it goes back to, we have these great cases. That's the case in South Africa. And I don't really want to go into how amazing it is, but I think that it's important to see where the gaps are and how problematic it in fact can be. With a few years down the line, we find that Ms. Curae herself, who had been the respondent in that particular case, died homeless in a shack. And the question is, even as public interest organizations, how we package and how we strategize in our submissions to court as Amicus. How are we structuring remedies, for example? How are we structuring even our arguments to make sure that there is substantive outcomes that can be felt on the ground? And I think that with South African cases, it's not that difficult to get entry into court, number one, when it comes to Amicus, but I think that the question will always be the impact and whether or not the impact is actually felt on the ground.
Right, and thanks for raising that for us. One of the things that came up in the publication, and we invite our participants to download the publication. It is available on our website, also on the invitation for this webinar. You can click the publication and just have a read through it. One of the things you notice is that, linked to what Masi was saying, a lot of the countries, the 7 countries, a consistent gap was that it's not possible often to tell in the judgment to what extent the court, even when it admits Amicus, has incorporated the arguments that came out and through that were argued in the court. So there's that gap, but then there's also the question on, okay, after the judgment comes out, what then happens after that Masi has raised. Another consistent issue that comes up is just a list of inconsistencies in general in terms of the practice of Amicus, or the lack of clarity, maybe I can call it that, which makes it such that even where we would like to approach the court through Amicus, there is a lot of lack of clarity and inconsistency in terms of like how and why to do this. And you can hear some of those challenges from the authors in a bit, but I wanted to start with you, Spoglin, to say, what is the cost of these inconsistencies? We know there's a lack of clarity. Sometimes the rules are not clear or the practice is not established. Why do we need it to be coherent? What's the cost of not having that clarity?
Obviously, when people do not know when to intervene before a court and what the issues are that are before the court. So the lack of consistency, there are countries that have rules, there are countries where the practice kind of developed. And when the practice developed because judges have made the law, there are things that will be covered and there are things that will not be covered, because they will set out what is there. So I'm going to talk about 2 kind of fora that we use. One is ECOWAS and also the African Commission, just to highlight the cost of not being able to have these very clear rules. In a concern around the jurisprudence on violence against women from ECOWAS, the court's inability to really understand what we mean when we say that violence is discrimination, or that the state is should be held accountable, even if the violence happened, at home, or it's considered to be in the private sphere. So just really giving information to the court to disrupt that. We went to ECOWAS, we submitted our application, and we got notification, and we went there ready to argue the amicus brief. This is in the Mary Sunday case, and I think people who are familiar with the case know that the decision, the final decision, still carried these kind of gaps. The refusal to acknowledge that domestic violence is something that can be attributable, to the state, can be attributed to the state if the state fails to act with due diligence to respond once that violation has occurred. We were not heard. This was a case against Nigeria, but they said the judges were French speaking and the court did not have the time to translate, and therefore on that basis, the amicus kind of fell away. And we couldn't challenge this decision because other partners who work in ECOWAS felt that because there is no rule, people have been going there and getting admitted, we shouldn't make a big thing about it because that simply means that it may become a problem for other people who want to intervene, before the mechanism. So of course, with all the work that had gone into this and it just not making sense. And then there is a very recent case, a rape case that was before ECOWAS. The case dealt with the rape and also the failure to investigate, prosecute, and punish by Nigeria again. And once again, we applied to the Amicus in this, it's ID versus Nigeria. It's a decision that was rendered about 6 or 7 weeks ago. But what happens in this case, we went there and the applications are normally had to be admitted at the same time as the main case. Just at the beginning, we were invited and we were told that our amicus has also not been successful. And the reason given this time was because this was an interpersonal case between the complainant and whoever it was that it was interpersonal to. So clearly, something that just did not make sense under any law, because how can it be interpersonal when there is a government that is being sued? This is a state, Nigeria is a state. So who is this person? And so they also continued to say that we were basically, by making this a public interest case, the intervention, then we were unnecessarily broadening the scope of what this case was about. The return was once again ECOWAS refusing to say that the state was accountable for its failure to investigate. And it's not only ECOWAS when it comes to women's rights. We have a similar problem at the African Commission. The African Commission continues to deal with Article 59.3 of the African Charter as something that forces it to have secrecy instead of confidentiality. So the new rules of procedure allow people to intervene as amicus before the commission, but the commission's practice is that people don't actually know which cases are pending before the commission. So there is this secrecy that even goes to the extent of parties refusing to share what they have submitted before the African Commission because they fear that the cases may be kicked out, although I don't know if this is happening, but because you have to keep it a secret what you have submitted there, because there is a reading of the charter, the thing that we call a misinterpretation that says that all decisions taken under the chapter will be confidential until, they have gone to the Executive Council. So what it means is that it's not just the decisions that have been taken by the commission, whether the state has been found accountable or not. From the moment you find your brief, everything is now covered by this, which really does not make sense. And so this continues to be a challenge when the laws are inconsistent, that you do not know at what point you can come in and what you can do, because you can imagine the cost of just doing all of that work to submit an amicus, and within 2 minutes it's kicked out without a really clear base, without a clear basis, and there isn't much, that you can do to undo what the court has actually done wrong. So it's always the challenge for us who do litigation, going to courts that don't have very clear rules or procedures, because you don't know what the outcome, is going to be.
Thank you for that. Yeah. And one of the other things that came up is there are some jurisdictions that seem to have more flexible, more progressive courts that are open to amicus that can allow them in, and others that are completely, strict or very critical of this. But what's coming out is it's dangerous either way not to have clarity. And the inconsistency, because the same court that today gets inflexible to allow you in because it seems
that they are progressive, if there is no certainty that litigators can know and say that these are the rules, these are the procedures, this is how you have it, this is what the parameters that make you qualify to be amicus or not, with the proper interpretation, it could be that it's good in this season, but you actually don't know what to be. They may choose to allow some people in and not allow. So that's a really interesting thing that's coming up. I want to come back to you, Kabi, and just hear some of the other inconsistencies or challenges, and give us an example, so we can just see what are some of the challenges. Okay.
I think what's good something she has said, but better. So something that she said that has really resonated is about this issue about when the rules become self-defeating in terms of admission of amicus practices. So for example, I mentioned that in Kenya, in some courts there are rules. Now in our Supreme Court, the rules require that an application for admission as an intervener or an amicus be done within 2 weeks of the close of pleadings. Now, a lot of the public interest issues that are litigated are not necessarily public interest in the sense that they will always be reported in the media. We know, for example, like matrimonial property disputes or violence against women disputes are litigated very much as private cases. And those present an opportunity for us to advance information to the court that would aim for social change. Now, when you have this limited window of 2 weeks to put in your application, that sort of becomes self-defeating, and it's presenting a big challenge. Because if you file after the 2 weeks, what the parties to the litigation, the direct parties to the litigation are going to say is that you are contributing to the delay in my case. And in Kenya, there is a significant backlog that parties have to grapple with as they go through the system to access justice. And within that 2 weeks, you not only have to put in your application, but you also need to put in a well-informed amicus brief to help the court see what you're trying to advance. And a lot of times, without that amicus brief, the court is going to say that your application is effective. And that's a significant restriction on the constitutional framework which underpins the participation of the institution of the Supreme Court. I can speak to also something that we're seeing coming out is a real restriction in how amicus should participate in proceedings. Now, while the Mutunga rules at the High Court level are really very broadly worded, we are finding more and more some courts are requiring parties to put in an application that all the parties to the litigation then have to respond to before making a ruling on amicus. And what that's doing is really sort of like delaying the litigation. And again, like I mentioned, if it's in the constitutional division, that's a significant delay, because just even 1 month is enough to push the determination of the case for over a year. And that's something that we're seeing is really now making the institution of amicus be frowned upon, and why you have we actually have had parties who approach you, the organization wants to put in an amicus bill. Why do you want to delay my case? So that means that you're going into a case where even the parties are not really appreciative of the significance of the case that's before the court. What I'm trying to go around is by restricting what you can then submit on and how you're going to participate. And we are seeing that as a problem because courts are then losing an opportunity for wholesome information from the experts. And secondly, because they're losing out information when they restrict amicus from making oral submissions. Because in practice, if you're making oral submissions, the court can intervene, ask for clarity if it's needed. If this would happen, we don't have to rely on the written brief.
Yeah, thanks for that. And another thing that came up in Kenya is that different levels of courts have different rules around amicus for practice. Would you like to tell us about that?
Yes. So yes, sorry, Dr. Nukura, I forgot about that. And that's the thing. So we've got the different levels of court, but at the magistrates courts, there are no rules whatsoever. And there is a perception amongst lawyers that amicus participation at the magistrates court is doubtful. Because the magistrates court should be applying the law, not interpreting the law. And there is much to that effect. But we need to interrogate what the role of amicus is and why is it that we think that magistrate courts cannot apply the law with the benefit of an amicus participation. We've seen in February that actually there is a magistrate court who recognized the need for amicus participation in a case involving a dispute on the status of a woman in terms of her marriage. And the court was willing to take amicus participation. But at the High Court level, now we have the Kutukan rule. At the Court of Appeal, until recently, there were no rules. And what this meant that was at the High Court, and this actually happened in a case that was determined this year, where at the High Court, the party had been listed as a respondent, sorry, as they'd been admitted as an amicus, and they gave their amicus paper as an amicus. But when we went to the Court of Appeal, what happened is that they were listed as a respondent. And but they continued the litigation. And the party who was previously amicus actually just continued to participate as respondent. But what does that mean? They participated as if they had a direct, I don't use the word interest, but a direct stake in terms of the litigation. And even at the judgment level, in the Court of Appeal, it's something that was picked up by one of the judges because it was a collegiate bench, and the judge said that it was wrong for this party to be listed as a respondent because that was not the role they were coming to play here. That's interesting situation continued on at the Supreme Court. And at the Supreme Court, then what happened is that now the court has to sort of like do this housekeeping. And this could have been sorted out if it is clear what a party who has played the role of amicus at a lower level, what role they continue to play as the litigation advances up the chain of the court.
Thank you so much for that. Back to Malawi, and we want to hear, from your context, what have been some of the challenges or the inconsistencies that have, made this practice not achieve what we wanted to.
The amicus practice in Malawi is very new. So in terms of jurisprudence, we have just a few numbers of cases that there has been amicus curie. The challenges have been that there is no real engagement by the court with the amicus applications. So the amicus would apply and advise the court on the points of law, the point of issues that are supposed to be interrogated. However, in the you find in the decisions that, of course, the court would acknowledge the amicus's contribution, but it's rarely you do not know which part of the section help the court in that certain issue. If the court is discussing about gender matters and they have been an amicus who have advised the court of gender matters, it is not clear which point was fundamental to the decision. So there's room there for improvement because it does not give much encouragement for amicus organizations to apply for amicus because you wonder whether your research or this addition of information to this court, if it is going to be relevant, and if it's irrelevant, is it worth it that is going to
is going to have the impact that you're hoping that the might come out of that. So the challenges, those are one of the challenges that the Amicus are rarely acknowledge their contribution is not that much shown in the decisions of the court, apart from just being mentioned that they were Amicus. Thank you.
Thank you for that. So we've spoken about, you know, why Amicus Curiae is important for feminist lawyers. We've talked about, you know, some of the challenges that exist in some jurisdictions that have the practice of Amicus, and we've discussed something about what's the cost of the inconsistencies and the challenges when it's not clear in practice, you know, rules around Amicus. Now I want to bring in another panelist of ours who contributed a very special chapter to the book because it, you know, the author is from a context that doesn't have the practice of Amicus Curiae. So what Ariane, you know, did is to try and help us think through what would be the value of Amicus in this context. Ariane, you know, I want to hand over the moment to you so you can speak to us about what you found when you reflected about the utility of Amicus in Burkina Faso. What is it that you think can be, you know, that we can learn from your reflection?
Ok, merci, vous m'entendez?
Okay, thank you. Can you hear me? Good morning. Dr. Ruth, thank you very much for the introduction. Before speaking on the utility of Amicus in Burkina Faso, I would like to make a small summary of the state, the present state of affairs. So Burkina Faso is a country that is a party to various treaties and instruments relating to human rights and women's rights in particular. But what is a paradox is that what we realize is that all these instruments that have been ratified or signed by Burkina Faso are not very known by the legal practitioners. These instruments are not mentioned before courts, and they are not well versed with them. And so for me, the utility for Amicus would then come from there. This would mean that its intervention would allow the popularization of laws or instruments and standards, international standards relating to women's rights. So more specifically for women's rights. I've lost her audio. Her network is bad.
L'intervention de l'Amicus au Burkina Faso, ce sont généralement des personnes.
Generally, yes. She's back online. I can hear her. So it's
okay.
Could somebody please check on her internet?
Okay, we'll come back
someone
to
please check on Ariane's internet
in a bit. But I now want to just welcome our participants. If you have any questions, please do type it in the chat. We'll be discussing in the panel, but in a moment we'll open up for questions and for responses. And before we get there, I just want to ask, because one of the things that the publication does is it dreams about the future, and it asks, you know, in your country context, what is it that you think should be put in place in order to get us to the place where we want to be in terms of consistency, clarity, coherence of Amicus practices. And I think I'll start with you, Beatrice, on this one.
Like I had noted earlier, the practice of Amicus is relatively new in Uganda, and the courts have been relying mainly on the inherent power of court in courts. And the power is under the various governments or the statute law, that is the Civil Procedure Act, and that empower the court to make or take any decision for the purposes of justice. And also Article 126 of the Constitution of the Republic of Uganda, it says that judicial power is derived from the people and shall be exercised in accordance with the Constitution. So with these various provisions, they're not coded in one single law. So recently, the Rules Committee has come up with the Judicature and Amicus rules, and these rules are meant to codify the procedure for admitting Amicus. And so this is helping us cure the lacuna in the law when it comes to admitting Amicus. And what I want the audience to know is that these rules are still a draft. They are yet to be signed for them to actually be actualized and used by the courts. So going back to the rules, these rules are actually the replica of what is stated in the previous decisions. That is the civil procedure, the civil application number 2 of 2016, which laid down the first principles for admitting Amicus. You find that these rules are replicating the same principles of neutrality, impartiality, and also the same that require someone to prove their expertise. So you find that the rules are also providing for the structure or the way how the Amicus application should be framed. So they give guidance as to how your application should look like, which I think is a good, it's good when it comes to who would like to apply for Amicus. And then also it lays down the procedure in the law, and it's mainly by notice of motion and also by invitation by court. So it gives us two procedures, how someone can be admitted as Amicus. It also gives us the time frames within which the application for the brief should be filed, which is 15 days after closure of proceedings. So the rules generally, even though they are still a draft, they are bringing about consistency in how Amicus is admitted in Uganda. And they are also actually giving effect to Article 126 that states that judicial power is exercised according to the aspirations of the people. And this means that the courts are open to people who are fighting for anything that's of public interest in nature. Then realize that with these rules also, we have the rules are generally are going to give us a way forward once they are signed by the Rules Committee, and therefore there will be no there will be consistency generally in how. And then this has also proved that once we are intentional with filing cases, we are able to create jurisprudence which can actually be transformed into law. And this is what we see, that there is that replica of what was decided in the application by Professor Luka Onyango to be admitted as Amicus in the election petition. that was filed in 2016. And so this is progressive for Uganda, I must say, given the fact that we have very few cases where Amicus have been admitted. First case, which is by Professor Okonya, that is the application to intervene as Amicus. And then, yes, recently the worldwide have been very also filing Amicus in Uganda. In this Libya's code 32, case that was filed by the Global Initiative, the Women's League has also been very fundamental. The reason as to why I'm putting this out is to show you how rare it's been in Uganda to have intervention by way of Amicus. And this has come in timely for the people who intend to create a feminist jurisprudence on issues of sexual reproductive health. It's high time we partner and you come together and we create this jurisprudence.
Thank you, Beatrice. For me, I think the Uganda story is just powerful because it shows that courts can lead the way and that it's possible to move from just through jurisprudence, literally like court decisions to clarify and to deal with these inconsistencies that we know courts can remedy their own challenges, and then the law reform can follow. Let me check in on Ariane. Is your connection better? Are you able to come in and tell us about Burkina Faso?
J'espère que vous m'entendez maintenant. Et que
I
c'est
hope that you can hear me now
clair. Vous m'entendez?
and that it is clear now. Yes, you can hear me. Yes. I was talking about the utility of Amicus when this was interrupted. I was saying that Amicus is useful to permit the jurisdictions in Burkina Faso to benefit from human rights perspectives, especially women's rights. And as I was speaking to Sipo Gili as preparing for this webinar, Amicus can improve the quality of decisions given by courts, and to also integrate regional standards and international standards in the interpretation of national jurisdictions regarding women's rights. So that's what I wanted to add on this particular point. I don't know if I was clear.
You were clear. Thank you, Ariane. And can you speak to us, Ariane, a bit more about, for Burkina Faso, what this would look like moving forward in terms of, and then like what would the steps need to be in order to try and conceptualize this friend of court in a context which it didn't exist? And you can also talk to us about the other intervention that's often conflated with, friend of court, but this is not actually what it is, and tell us if you see this as an entry point or what steps would we take to try and do that for Burkina Faso.
For me, as we do it generally in law, the reforms are usually in two ways. So we have the first avenue, which is a through legislative reform. So it's a legislator that then discovers that we need to put in place reforms to authorize the admission of Amicus in procedures, and and he needs to also determine the criteria and the process. The second proposed avenue is then through the courts. So sometimes we will see that jurisdictions would take matters into their own hands by doing what is independent, asserting their own independence, and then interpreting laws in ways that would impact law reform. So they could actually give a progressive judgment that would then lead to reform. And what concerns particularly Amicus, this opening by the courts could be envisioned through a mechanism that is already in place, which we call experts. So in Burkina Faso, we do not have Amicus, but there is, within the jurisdiction in Burkina Faso, it is allowed that in certain cases, she has dropped off the call. Okay, she's back. Her mic is muted. I think she's having challenges.
Est-ce que quelqu'un m'entend?
She's back online. I am unable to hear her.
Okay, I think that's fine. We'll just try and wrap up here and just let us know if the connection comes in. By hearing from the panelists what you believe the future is, and I'll come to you, Basi. There are examples of cases where Amicus has been used to advance women's rights cases. Can you tell us about that? Just by giving us examples and tell us what does the future for South Africa look like?
Sure, thanks. Amicus has been used as part of the legal strategy. Keep coming back to this idea of strategizing. And even with women's rights cases, it is only one part. What normally happens in conjunction is that there is also activity, at a parliamentary level. There's advocacy that is also brought into play, and then there are also other strategies like media strategies that are often used when advocating for various rights, using the Amicus sort of application process. But one of the challenges I think that still remains is, and something that is still unclear, is the participation of Amicus in criminal cases. And that is something that I think is still a huge gap. I think the most significant sort of case there is the SB Zuma case. And even though in that case Amicus was allowed to make an application, the application ultimately was rejected. And part of why it was rejected is going back to the strategy that the lawyers at the time had implemented in their submissions, where what they had wanted to do there was to make comments also generally about women's rights and the Constitution, but effectively what ended up happening is that in some of those submissions, they spoke quite closely to the individual who at the time was the complainant, and the judge who then ultimately rejected that application had said that, you know, the Amicus themselves had jumped the gun because they had automatically assumed that the court, or rather the judge himself, wasn't privy to, you know, women's rights, wasn't privy to the intersection with the Constitution, and that it seemed like it was a personal affront that he had taken from the submissions of the Amicus, that, you know, essentially they were trying to sort of influence the outcome of the case, and that they weren't really focusing on generally providing the court with, you know, information that was going to assist the court in finding, in making their findings. And so in a sense then, I think that there's just been a reluctance and very few situations that I'm privy to where, you know, organizations like the Center for Applied Legal Studies, for example, where they have tried to intervene in criminal cases as amicus. And I think it's quite important to consider that because we know that a lot of, you know, violations against women take place are criminal in nature. And that what we also find is that they do happen, for example, in your lower courts, like the magistrates courts, and in, you know, significant sort of criminal cases like the SV Zuma one. So I would say that going forward, something that the Treatment Action Campaign case has taught us and shown us is that cases can be won even before you enter the courtroom, and that can be done by coupling your litigation once again with strategies like research, advocacy, and coupled with the media strategy, that by the time that you go to court, you've already won outside the courtroom. So if your amicus application is even rejected, it doesn't matter at that point. But then how do we make sure that those judgments that are positive resonate and connect back to the affected people? And how do we make sure that there is impact that is felt on a wider scale on the ground? Thank you.
Thank you so much for that. We've received one question that has come from the floor. It's connected to what you're saying about, you know, what's the impact of limiting amicus participation only to providing, essentially, in what kinds of legal proceedings should amicus be limited to? Can you bring it to all kind of trial processes? Can it be applied in criminal matters, or is this something that we should only see as of constitutional petitions? And I want to see if there's somebody from the panel who wants to respond to this based on their own context jurisdiction as well.
I mean, just building from the example used by Basitana, the state versus Zuma case. And one sees the challenges of bringing amicus in a criminal trial like that one. Because part of the controversies of the amicus intervention there was, for people who have been learning this week about survivor-centered and victim-centered approach, the complainant had specifically said no to this amicus intervention because the cross-examination and everything that happened to her when she first took on the stand was extremely dramatic, right? There were people outside with placards who defended Zuma. And the risk of amicus in that case, although amicus didn't deal with the facts, was that it was going to kind of expose her to being recalled, you know, to give evidence, because what had happened there, the issue was she had said, you know, she froze, during the attack, so that's why she didn't scream. And part of what Amicus wanted to submit was that there wasn't a typical rape victim. So this idea that when you rape, those kind of rape myths, there is a particular way to act, and it proceeded to whether she asked for money in the morning, like taxi fare in order to go home. So basically, Amicus really kind of tries to contextualize. So from a very from where we stand, one can actually see why that would have been helpful. But in the way in which a trial, a criminal case, because here you are giving this evidence or this amicus, and the thing is to say, is this what happened to her? So the need arose under what she was asked during cross-examination to correct that actually there is something here, right? So in some ways, the amicus is beginning to deal with the facts, of the case, like evidence, like some kind of rebuttal that there is a typical rape victim. And so it's not just saying, let us develop, the law. Is you look at something that was said and didn't sound right, and then you go back and then you engage with it. So then it begins, to blur the lines, between being an interested party or an amicus, of the court. But in this case, what made it very like a sore point and a serious split, which I don't know if it will ever be healed in the South African feminist movement, is about who goes to court when the victim has said no. So this idea that legal organizations are so lawyer-centered that they actually didn't care or listen to what the victims and the people who were supporting her, because they didn't have direct contact with her. And they also said they felt like there was gatekeeping by the people who were supporting the survivors. So in the end, even though she said, no, not sure about this, they felt like that's not what she was saying. And to make it worse, this was a rape case. So once again, it's like, we didn't hear your no, or you consented to this through your actions. So, but going back broadly, this is a case that really highlights the kind of challenges when there is a criminal trial that is taking place and then there is amicus, because the evidence sort of comes later. You don't start with a question. And I think if this, in a trial situation, you're looking at what's happening right now with the defamation case, Johnny Depp and Amber Heard. And that's the question, people are asking, why is there no amicus, submission to try and contextualize some of the things that are said there, about the nature of her injuries, about the inconsistencies in her testimony, and all of that. And so I think what is it that we're trying to respond to, but if it is triggered by the facts than the law, then that's where we know we may have a challenge about the role that amicus can play.
Thanks for that, Spokely, because you just actually reminded me about how, and unfortunately, we just got a message that you can't join us, but our author from Botswana highlights in his chapter the ways in which amicus can be misused sometimes and even, abused the friend of court, and some of the challenges that goes on to create later down the line. The conflation of interested party and amicus, so people acting, not using it as it should be. So, and what it was reminding me is we are not saying that, in trying to find the value and the utility of amicus curiae for feminists, it's about saying what goal is it going to actually serve? How are we using it to develop feminist jurisprudence, and what is it that we want to actually, get from the court using the amicus? So I'm glad you raised that. Okay, so do we have any other question online or participants that want to unmute to speak? Okay, well, if there's none, I want to take the liberty to ask a question for the participants who are in the room, because they are feminist litigators who are actually going to be, assessed on amicus curiae. And the question I have is for you, Spokely. often when we are, developing feminist jurisprudence and we are engaging the court, we can engage as parties or we can engage as amicus. What is the difference between those two ways of engaging the court? Because it affects the way in which the brief is drafted, right? So what would, a good amicus brief do in terms of how we want to use this institution of amicus as opposed to, an ordinary pleading that would be applying itself to the facts and things like that?
In making the decision really about the role that one wants to play, there are instances where if the main party decides to abandon the case, then there is nothing that amicus can do. That's the end of that intervention. So that's one thing. It's about who are the parties, in this case, and do you have a case if there are no parties, and do you have a compelling interest that will help make you a party? So normally the partners who are here, when we file cases, we normally file with the client so that even when the client decides to leave, we have an interest at stake, as a party, because this is an issue that we want to raise, and then we go with it, especially when we are challenging constitutional provisions. The second thing is on the road is, as we've seen, is we can be admitted or not admitted, as amicus. And if you're not admitted, that's the end of it. So one of the things that we want to be able to do, I think one of the things that ISLA exists for is to develop feminist jurisprudence. So the role that we play, whether we are advisor to counsel, is first determining the strength, right, of the legal representation, especially when we're not working with our network partners. Because you don't want to get amicus to the case that's unclear, and you hear actually they are not arguing that anymore. Because now your amicus is raising issues that have got nothing, to do with the case. So this is a challenge in terms of how our amicus procedures are developing. I do raise also in the book, in the publication, that because of the rules that are unclear, there are amicus there is a way in which amicus actually engages like a party because of the close relationship that amicus sometimes have in other jurisdictions with the parties, that they sit together, they plan together, they decide who's going to make which submissions, right? And of course, think that we should frown upon, even if we see it as something that benefits us. In other jurisdictions, the rules are so strict that the party cannot even give you the brief. They will say, yes, we know, and we think your brief may, what you want to argue may help us, but you have to go and get the set of pleadings, from the court, just so that we are able to have a very clear distinction, because we don't want to fall into that collaborating with amicus, for that the amicus is actually not neutral. So what this means is, when we look at amicus briefs that have been really helpful, these are the ones that don't touch on the facts of the case. These are the ones that are very clear about what it is that they want to say to the court, so the court can actually appreciate. Because when you look at good amicus, it's very hard not to see your amicus intervention in the decision. When the court has listened to you, you will be able to see the things that you wrote, even sentences and sometimes paragraphs of your submissions, making their way to the judgment. So I'm going to make us a couple of examples of cases where you actually do see the amicus. In Kenya, we intervened in the Mitugal case, where the lower court had said that the Kenyan courts the remedy of structural interdict is foreign. It's not a remedy that's available or provided for under the Constitution. We went there to make a submission about why the right to remedy encompasses all types of remedies that are possible, because at the end of the day, you want the person to have a remedy. So a remedy doesn't have to be specified, right? And so we went and started telling the story about like where there's a right to a remedy, and also how courts have been fashioning remedies. So the strength of our submissions was on comparative law and how various jurisdictions deal with the remedies. And you do see that. And there is another case, the case of Dr. Tatu versus the Attorney General, which was a case on a challenge to the anti-abortion, to the abortion law, the FGM law, the anti-FGM law. The abortion is like everywhere. So what happened, our submission there was on a very specific point around the state obligation to protect, that even if, as the applicant in that case had said, this violates my right to practice my culture, right? I'm an adult woman, so it also violates my kind of bodily autonomy. If I want to have this practice, I should be able to do that. And so what we were doing was to say, there's a lot of ways in which the state protects us, even when we say we don't want protection, right? We've got all of these laws on domestic violence. We've got laws, you have to wear a seatbelt, you have to have a helmet, and all of those things. So it's not new, it doesn't start here. When, in order to protect us, the law does that. And so that was the nature, of the thing, to say that it's not just when it comes to your right to culture or custom that now the law has to be like hands off, this person has got autonomy, because that's what the state obligation to pass laws that protects us from violence is about. One of the biggest cases to ever come out of the European Court of Human Rights on protection of women from violence is the case of Amicus versus Curae, especially in domestic violence cases. In that case, Interrights made submissions before the court, and what they were doing, because the state there, Turkey, argued that there was nothing that they could do in a domestic violence setting where the applicant would go and then withdraw charges. They would go and then withdraw charges. And what that amicus brief does is basically to walk the court through the state obligation once again to protect that you do understand violence. Some people have said that it is cyclical. We understand what it is that people who are victims of domestic violence don't follow through because they don't want to see their husbands or partners, in prison. They simply want the violence to stop. So what triggers the state obligation? It is triggered when you know or ought to have known. So even if she walks away here, you know that her life is in danger, right? Because that's how domestic violence works. So when you deal with domestic violence as you would do with other criminal offenses, then you are failing to protect, because here there is a gap that comes across simply because of the way in which domestic violence occurs. And so the strength of the amicus submission is to show the gap, that when you just say it depends on the person who has come to the police station and if they withdraw, and then using international human rights standards, Convention number 19 or the model law on the protection of women from domestic violence, to actually show that this is why this law was needed. So if you have a law that doesn't include civil and criminal remedies,
that just centers the response on criminal law, then you have failed in your obligation, to do that. So there has been a number of cases where amicus submissions have really helped the court to see the gap and also why the law actually needs to take into account how various violations actually happen and why it is important in order to protect women to have laws that look above.
Thank you so much for that. Yeah, it's really useful to see that this is it's an intervention that Amicus, that feminist litigators have used, and that indeed it has worked, and that it's possible to use this intervention to develop feminist jurisprudence. It's just very hopeful to hear that. Yeah, so I'll check in on you, Ariane, one more time, because we really do want to hear you. Can you just give me a shout out whether you are able to speak to us? I think we don't have her. Okay, so we'll take our closing remarks from our panelists. And I'll start.
Est-ce que vous m'entendez?
Yes, can you hear me? I am here.
Yes, we can.
Okay, thanks.
Merci. Thank you.
Okay, so we wanted to.
J'ai pas entendu la question, s'il vous plaît.
I did not hear the question, please.
No, we just wanted you, if you still wanted to finish your thoughts, because you were telling us about, the steps that Burkina Faso can take to, perhaps institutionalize Amicus, whether through the courts or law reform. You can take this opportunity to also give your final remarks.
Merci beaucoup. Là, j'ai bien compris.
Thank you very much. It is clear. I was speaking to the possibilities and opportunities that we can explore on the reform on the issue. I first spoke on legislative reform. So this means that it is the legislator that decides to proceed with this reform, while by placing amicus in and placing a procedures on that. And the second opportunity would be for us to see an evolution on jurisprudence on the question. And so this comes back to the courts to have a progressive interpretation of the laws that are existing so that we can progressively get to the development of the intervention of amicus that would benefit women's rights. And there are so many experts that can bring their contributions to the courts. I was saying that on this aspect of reform from the courts and from jurisprudence, we can have a little hope, because even if amicus in its sense is not particularly recognized in Burkina Faso and is not admitted in our procedure, there are other ways that exist, for example, that speak to experts. So the jurisdiction can then ask and invite the opinion of an expert on a particular issue or question that is complex for the courts, to the judges. So through this interpretation of these resource persons, we can hope that this gives the opportunity and opens the way for Burkina Faso for Amicus in Burkina Faso. And so as then the courts then can make pronouncements on these based on the opinions of these experts, and then this may lead to Amicus being recognized, and at a certain point the legislator will then see that they will be obliged to recognize Amicus intervention, because there would have already been fertile ground for the admission of Amicus. And so this is what I wanted to add on this particular topic. Thank you.
Thank you so much, Ariane, and we are grateful that you joined us for this webinar. We'll start off with our closing remarks from Yokabi. There was a question that was put to her that she will refer to as well as you close.
So there was a question on whether there are organizations that offer pro bono public interest litigation. I would encourage the participant who asked that to please get in touch. There will be some contact text in the chat box, so you can get in touch. Some of those organizations are represented here today, and I'm sure you will be directed to the correct organization for your specific issue. In terms of, I think, the conversation we've had here, I know it has seemed like we talked a lot about the challenges, but just like Bobina has said, there is definitely somewhat in terms of what Amicus interventions have done for women's rights litigation in Kenya. We have seen the jurisprudence we asked to work with the social change, because of course it is a journey that does not necessarily end in court. For the future, I think what I would like to see is less restriction on participation of Amicus, of course within reason, but there is of course concern that the more restrictive it gets, then the less legitimacy that it can play. So we can continue to hang on to the hope that at least very many courts now are inviting us as organizations to participate in cases as Amicus, and hope that that is a practice that becomes a little more widespread throughout the country. Thank you very much for your attention and question.
Thanks. I think from my side, what I would like to see more, which something that happened this year with Malawi, was the court there had opened Amicus applications to international sort of expert organizations. And I would like to see more of that happening so that we can really share some of our expertise and to have other, organizations from various jurisdictions as well share their expertise. So maybe that exchange, and it wasn't necessarily successful. We are the court itself in Malawi is still deciding whether or not to hear the Amicus applications. But I think that it is a very interesting step in the right direction, and I'd like to see more of that happen.
So one is clarity for everyone. You know when you can intervene, you know what you can intervene on, and also just the process is also clear, like how you can go through the step. This at the domestic level and also regionally, because we are really deprived. The not knowing, the hesitation has an impact on the quality of the jurisprudence that's coming from the places where, from the accountability mechanism that are available to us on the continent. And feminist jurisprudence is not going to build itself. So we are going to need feminists who goes there and set the trajectory.
The important thing is most of these cases are won. And I think at the time, a win is a win, you know, but it does not necessarily mean that the issues of state accountability or feminist jurisprudence is developed. We have won cases with terrible legal reasoning and analysis when it comes to the women's rights question. And that's what we need to be able to correct. And that's what feminist amicus briefs will help us to get right.
For Uganda, I'm looking forward to seeing amicus briefs filed on behalf of women to the advanced jurisprudence on women's rights, and also from a feminist perspective, because the analysis in Uganda that all the amicus briefs that have been filed have been for political purposes and not for issues of public interest in terms of women's rights. So with the new rules in place, if they are defined by the rules by the Chief Justice, then we have a proper way how we can have access court without any form of interest. So to me, that is what I hope to see new jurisprudence on women's rights, specifically in Uganda.
For me, in Malawi, there has been a lot of progress in that the courts are more willing to accept amicus applications. They even invite applicants to come and bring the wealth of information to court. And like Basipana has said, even inviting international applicants to come and advise the court. So there's a lot of progress in that the courts are very willing. What I'd like to see more is their engagement with these applicants, the amicus that have provided their information in court, what their linkages to the application and the advancement of jurisprudence. So if there is more of adopting the amicus application and interrogating well, making it clear, they are being more forthcoming in terms of what the amicus have contributed in that application. I think we'll be selling very well.
Thank you so much, everyone. We know for sure that the future we are desiring is one of less restrictions and coherence and clarity. To wrap up, I just want to say that this was actually the first phase of a project that ISLA intends to keep working on. The first phase was to develop comparative perspectives from African, domestic, national level jurisdictions. And then we, in the next phase, will be considering a comparative perspective regionally and how the mechanism, some of the issues we started talking about, some of the inconsistencies and incoherence there, and then work towards a process of, it would be nice to have a model law, on amicus and how that can set the standard for clarity and how that can affect what's happening in our jurisdictions. Our publication, will be translated in French, and this will be shared online, and so it will be available for both the Anglophone and Francophone contexts. And lastly, just to appreciate GIZ for the support, in the development of this publication, and really everybody who pulled through to see it from the beginning through to the end. Thank you to the ISLA team, Amor, and others who really supported us to get to the end, and even to the other authors who are with us in the room but were not part of this panel. Thank you so much for your work.